Aussizz group Perth. I'll connect Instagram as well, so just bear with me for a second. All right, everyone. Good afternoon again. Welcome to live session from Aussizz Group. My name is Alpesh Patel. I'm a registered migration agent over here in Aussizz Group. If you have any question, please feel free to comment in the comment box, and I'll attend them at the end of the session. Today, I'm going to talk about partner visa. As you would be aware that there are two basically partner visa subclasses, subclass 820/801 and subclass 309/100. One is onshore, another one is offshore partner visa. But before we go to that, let's start with some statistics about the partner visa. I'm sure the main concern would be is why the partner visa applications are taking longer time to process. So to give you some information, the current processing time for 50% of the application, offshore application subclass 309, taking 11 months, and majority of the application, which is 90% of the applications, are getting processed in 24 months since the date of submission, since the date of application submitted. The other one is onshore partner visa application, which is subclass 820. 50% application of such applications are getting processed in 5 months. However, on the other hand, 90% application get processed within 33 months. To give you a bit of more information on that one more is prospective marriage visa, that is anywhere from 10 to 25 months. Now, the common question is like, why the processing time varies from application to application, and for 309 and for 820 as well. So this depends on many different factors, such as the country of the applicant's passport, the relationship duration in between the sponsor and the applicant, how did they meet each other, whether this is the first time sponsoring or the second time sponsoring, what was the past history of the applicant and sponsor as well. So the department take all this into consideration before they make a decision on the application. Hence, some application may take longer time, whereas some are kind of straightforward as well. To give you some information on the migration planning level, for 2023 and 24 financial year, the government has allocated 40,500 places. Whereas for the financial year 2022 to 23, it was similar, which was 40,500 places. It was completely different in the past. In 2022 to 21 financial year, the number was 72,300. Yes, that were almost like 30,000 more seats than what it is currently. So obviously the department, even the application is at the stage of finalizing. If the number has reached to 40,500 for the financial year, they will not unfortunately grant the visa, and they'll have to wait for the next financial year to start. Now, to start with onshore partner visa application, which is subclass 820/801. Whenever the partner visa application is submitted, it happens in two different stages. One is the applicant's application, and the second one is the sponsorship application. Applicant, when the application is getting submitted, it is actually getting submitted for two subclasses, 820 and 801 at the same time. Hence, the department is charging $8,850. I understand it's too much. It's not still justifiable, but this is the situation. So when 820 is granted, in 2 years' time, from the date of the first application, the department may send an invitation to apply for subclass 801 if it is not granted together. At that time, when you apply for 801, the department does not charge anything. Now, who can apply for subclass 820/801? The applicant has to be in Australia, whoever is going to apply for the partner visa application. They must be a substantive visa holder. If they are on bridging visa holder as well, then they also can make an application, which I'll come on that one. But they must be substantive visa holder with not having 8503 condition on that visa. So to give you a scenario, if you are in, let's say the sponsor is over here in Australia, inviting the spouse on visitor visa under family sponsor stream. Now, as per the regulation, when someone is invited under family sponsor visitor visa, this condition 8503 is mandatory. So the visitor visa will be granted, but it will be coming with that 8503 condition. In that situation, that applicant, when she or he is in Australia, they cannot submit this onshore partner visa application. If, on the other hand, if the visitor visa is applied under tourist stream, there are kind of 50% scenario of having the visitor visa granted. And in that case, majority of the scenario, that 8503 condition is not imposed on the visa grant letter. That's when the online onshore application can be submitted for 820/801. Just a minor correction for that family sponsor stream, not necessary that it will be granted, but the chances of having granted are higher compared to under tourist stream. Now, on the other hand, about being on bridging visa and applying for partner visa application. Yes, it is possible, it is lawfully allowed. But the department will be asking you to justify that why the applicant could not go offshore to submit this visa application. In the migration terminology, it says Schedule 3 criteria need to be satisfied. Schedule 3 criteria can be satisfied only when there are compelling and compassionate ground that the applicant could not go offshore to submit this visa application. So, for an example, if the applicant has some sort of medical condition and could not depart Australia to submit this offshore partner visa application, in that case, Schedule 3 criteria would be satisfied. But it is advisable to submit an application offshore instead of onshore if you are a bridging visa holder. Now, when the bridging visa B becomes active, when the bridging visa, when onshore partner visa application is submitted, the applicant will be granted a bridging visa. When the bridging visa A is active, that's when they can do full-time study and can work full-time as well, unlimited. As soon as the onshore application is submitted, they are able to basically apply for Medicare card. They don't need to wait for the bridging visa to be active in that situation. Obviously, onshore partner visa application has multiple advantages over to the offshore partner visa application. So for the offshore partner visa application, that is called subclass 309/100. As the name suggests, basically the applicant should be outside Australia. That's when they will be able to submit this subclass 309/100 application. The department fees for this subclass is exactly same as the onshore partner visa application, which is $8,850. When the application is submitted offshore, they cannot be granted bridging visa straight away. Yes, it can be obtained afterwards. That's completely different scenario, but it will not be automatically issued. Obviously, everyone would like to apply onshore partner visa instead of offshore partner visa application so that they don't need to stay apart for like 11, 12, or 24 months. But it is also possible to apply offshore partner visa application and then apply for the visitor visa for the applicant to come and spend some time with the sponsor in Australia. There are higher chances of having that visitor visa granted, but again, it has been noticed that in some cases it is getting refused as well. Now, coming on sponsor situation. So the one which I have explained is about an applicant. In both cases, offshore and onshore applicant need to satisfy the character requirement and health requirement as well. That means to say is that they will have to undergo the health examination, and in terms of the character requirement, they need to obtain a police clearance from that country. Not just from that country wherever they are residing, but wherever they have spent more than 12 months in past 10 years. From all those countries, the police clearance need to be provided to the department before the department make a decision. When you submit an application, if you do not have police clearance, that is okay. The application still can be submitted, and police clearance can be provided to the department on the later stage before the decision is made on the application. The minimum age requirement for applicant would be 18 years of age. Under 18 years cannot apply. It's basically not legal in Australia. The applicant must have married to basically in basically one relationship only. If they were married earlier and the divorce is not finalized, they cannot get married and then apply for this visa. At the time of an application, the department need to be supplied with two Form 888. Form 888 needs to be filled by Australian citizen or permanent resident or eligible New Zealand citizen who knows about your relationship and who can basically vouch about your relationship. They need to be provided along with their identity documents as well, if the department wish to verify those Form 888's the genuinity. The more information provided on Form 888 is usually better. That way, the department is going to have some sort of surety that the relationship is genuine and ongoing. That's what basically the department is trying to understand from the partner visa application. Now, coming on sponsors requirement. So, same as applicant, sponsor cannot be under 18. Again, it's unlawful to do that one. The sponsor must be of good character. So in that sense to say is that the sponsor also will require to obtain police clearance from the country wherever they have spent more than 12 months in past 10 years. They should not have any family violence case against them. And most importantly, there should not be any substantial criminal record against the sponsor. In some cases, that can be waived as well, but depends on the ground and case-to-case basis. The sponsor comes with the sponsor's limitation as well. So that means to say is that if someone has been sponsored on partner visa application, let's say in December 2023, that relationship broke down in July 2024, and now wants to get married and wants to sponsor someone else in August, September 2024, then it's not possible. There has to be 5 years gap in between the first application made to the second application granted. So just to give you a scenario, for an example, in the month of January 2024, in the month of January 2020, let's say person A got the partner visa granted. That relationship continued until December 2023. In the December 2023, they got divorced. Now person A got married to someone else again and wants to submit a partner visa application for whoever he has married to. That is absolutely fine because that's going to be 5 years by the time department is making decision. But in case the department is making decision before that 5 years, in between one application submission time and the second application decision time, then it's going to be refused. So the time frame need to be calculated wisely to make sure that you're not being in trouble. Okay, any person can sponsor or can be sponsored maximum basically 2 times. So for an example, let's say I got my permanent residency because my wife sponsored me on partner visa application. Now my relationship broke down and I want to sponsor someone else. That is possible as long as that meeting that 5 years requirement. Now, the second relationship, the one which I'll be entering into, that is also breaking down in 2 years' time. And if I want to sponsor the third person, then it's not going to meet the requirement. Again, in this situation as well, in certain cases, if there are compelling grounds, then that can be waived. General situation where these sort of limitations can be waived is basically if Australian child is getting affected by having that sponsorship imposed onto the sponsor. Um, Now, coming on this situation about marriage. To apply for subclass 309 or A20, you must be married or in de facto relationship for 12 months before you submit an application. There is a good facility in certain states and territories that if your relationship has not finished 12 months as a de facto relationship, then you must, not really must, but you have an option to register your marriage with that state or territory relationship registry. And once that is recognized by Commonwealth under the migration regulation, then you can apply for the partner visa application before you finish your 12 months de facto relationship and not being married as well. This facility is not available in every state. The state which are exempt is basically Northern Territory, Western Australia, and South Australia. So I'm sorry to say, but if you're listening from Western Australia, you do not have this facility to register your marriage and apply for the partner visa application. In what context this can be used by a sponsor and applicant is, for an example, if someone is an NSW who is permanent resident or citizen, he is in relationship with someone who is in, let's say, Nepal for 6 months now. Usually in this situation, if you are in WA, then you should be applying for prospective marriage visa, which is subclass 300, or you need to get married, or you need to wait for 12 months before you can apply for partner visa application. Whereas if you are residing in NSW, you can register your marriage despite sponsor is in Australia and the applicant is outside Australia. NSW allows that to happen. You can register your marriage once it's recognized by the Commonwealth under the migration regulation, then you can apply for the partner visa application straight away. This has also been noticed that people do apply for prospective marriage visa and then after they convert into the partner visa application, it is possible. But we have noticed that it is taking longer time and instead of basically expediting your process. So whether you should be doing or not depends on your situation, which we can discuss and come to the conclusion for your particular scenario. As you would be aware that same-sex marriage is also valid in Australia. All the other requirement for them is similar to how I have explained for subclass A20 and 309. This partner visa application get granted on base, basically assessed on base of your relationship with whether it's genuine and continuing or not. How the department is going to assess this? So for that, you must be providing relationship documents of 4 different aspects of your relationship. One is financial aspect. Second one is nature of the household. The third one is social aspect. And the fourth one is the nature of your commitment to each other. There are multiple documents which can be provided. It is obvious that if you are not residing in the same country, you will be having limited documents in terms of your household responsibility and the financial relationship, financial aspect as well, which department is aware of that one. As long as you have done your best and provided the documents what possibly and legally were possible to obtain, the department will be considering them. Just to give you some sort of information on what sort of documents can be provided under each aspect. Financial aspect, you can provide joint ownership of the any real estate or have any mortgage or joint bank account. If you have been transferring money to each other or supporting each other or paying like tuition fees of one another one, all those sort of wherever money is involved, those can be provided where you basically have both of your joint name. Superannuation statement as a beneficiary can be provided as well. If someone is in India, for an example, they can and if they have the life insurance, the beneficiary can be shown. That will help as well from the financial aspect point of view. Nature of a household is living together if they are in the same country, having joint lease agreement, utility bills, and both of are having same mail address. If they are living in different country, then that can be explained that, okay, because of not in the same country at the moment, you don't have joint lease agreement, but down the track, this is your plannings are when the applicant will be in Australia, that you'll be living together, and this is how you're going to save money to have your house, or you'll be having joint lease agreement, and some sort of indication that you have really planned for your future. The third one is social aspect. In terms of social aspect, is basically how well known your relationship is in the social life. So that can basically is about that statement from the family and friends about the nature of your relationship, evidence of your joint activity, including sporting, culture, social activities, evidence of declaration of relationship on social media platforms such as Facebook, Instagram. You can show that now you're married to whom and so on. So it's basically socially recognized, and it's not just basically you and your spouse is aware of about your relationship. That's where the department is going to have more doubts, and eventually they're going to take more time. The last one about that is the nature of commitment. Over there are so many different aspects which can be considered by the department. To start with is the duration of your relationship. What does that mean is, for an example, if someone has got permanent residency granted on 1st of February, got married on 15th of February, applied on 16th of February, and it is mentioned to the department that you just came to know about each other only on 31st of January 2024. Just one day you decided to get married, and then everything just happened in 15 days of time. It's kind of suspicious that the department is going to look at it. Department is going to look that situation in a suspicious way. In this sort of cases, the department is going to do more investigation, and eventually it may delay the process. So it is important that the department has been provided the required information in a transparent and honestly. If you knew each other before your permanent residency granted, yes, you should declare that one. As long as you're not in a relationship, excluding, I mean, you are not in a relationship such as a married couple, then that's fine. So don't hide such information from the department. Uh, the next one can be is the degree of the emotional support that you are providing to each other. Over that, it can be explained like how you are getting sort of emotional support from your partner when you are feeling down, or whenever you need some sort of help, or it's just probably one of the bad day, and when you speak with her or him, you feel better. Then that can be explained over there. Um, for for this all aspect, the sponsor needs to provide a statutory declaration where this needs to be explained how how your financial aspects are there, natural and social aspect, and natural commitment are there. Those needs to be explained to the department in a nice and in a detailed way that the department can understand, that you have understood about your relationship, and it's not basically a kind of come and go situation. So that's basically all about this partner visa. The current processing time is obviously a bit high, but not necessary that your application will take longer time. Just to give you a scenario, for an example, I submitted one application. The applicant was from Philippines, and that was offshore partner visa application, which is subclass 309. That was granted in 3 months' time. So yes, it was a different. That case was different to probably your case, and your case may genuinely take longer time, but my understanding, and this is my practice as well, we don't just should completely like do follow with the department that because of the emotional grounds, this is affecting your relationship and so on, the department is unfortunately not going to expedite your process or your application process just because of those sort of situation. In that case, you can apply for the visitor visa application so that he or she can come and join you over here and can spend some time with you. So now I'll be going on the comments. Guys, my contact information is on the screen as well. So if you are listening this video after this live session, then you can send an email to me, or you can contact me on that number, or you can contact our office, and they will be able to help you. So there is a comment. Sorry for being off topic. Can my subclass 482 employer nominate someone for subclass 407 training visa? It is off topic, but so if your your employer's SBS has been approved for subclass 482, then it cannot be done for 407. It cannot be done in the sense is they will have to apply for SBS again for subclass 407. So standard business sponsorship for 482 and 494 is different to subclass 407. This one is again, I have 90 points for subclass 190 and 85 for 189, currently employed as chemical engineer in WA. How good are my chances for this year or next? I understand an invite is not guaranteed. You must be aware, Nitesh, that WA doesn't have any seats left over for the financial year. Unless and until additional seats are given by the federal government, then they may do the invitation round before this July as well. But other than that, from July onwards, 90 points is good score, good chances of getting invited, as long as your visa is not expiring before they make an invitation round. So you just need to be mindful of that. There is a comment from Ankit. In health examination email, it mentioned to done within 28 days. So should I be done within? Okay, so the question is basically, whenever the HAP ID is generated automatically, mainly, it gives you 28 days. If you do not find any spot for the medical examination from the approved health professional, then you need to book a medical examination and provide a confirmation letter to the department stating that it is happening on certain date, just because you couldn't find any spot prior to that. So for an example, if you have applied today and you have been given 28 days from today, and you are finding the first available on 15th of April, then that is okay as well. As long as the department has been made aware that you have done your best to obtain the seat and you have done the booking as well, then the department will wait for that. What's the difference between 820 and 309? So once that 820 or 309 is granted, there is no difference. The only difference is at the time of application, so which is 820. To apply subclass 820, you need to be in Australia. To apply for subclass 309, you need to be outside Australia. The department has made an amendment recently that subclass 309 can now be granted while you are in Australia as well. So for an example, if someone submitted an application while they were in India and then came to Australia on visitor visa, and the department wants to grant 309, then that can be granted over here. Earlier, that was not the situation. Majun is asking, can I apply for the temporary graduate visa through the study of diploma and not a master? It depends what diploma you have completed. On base of that diploma, if you have 485 facility, then yes. So for an example, if you have studied diploma in business, then no, you cannot apply. If you have done certificate 3 for cookery and diploma in hospitality, then yes, you can apply. What is tentative processing period of nominating process for subclass 407 intern visa before lodging visa? Well, subclass 407, I would suggest that you send me an email for that one, and I'll be able to help you on that, because I need to understand the occupation to answer your question. Um, which is the Anurag is asking Tasmania painting 85 points, which is the best state to do job ready program in painting. Well, job ready program can be done from anywhere. That basically doesn't make any difference on permanent residency process. It Once you complete that job ready program for 12 months, it will award you 5 points as an experience. That also, even if you have done in Sydney, Melbourne, or Perth, or in Adelaide, that will give you the same points. So that basically doesn't make any difference whether you should be doing from South Australia or from Western Australia. Ankit is saying that book it in April to June. What should I do? Sorry. So you are asking further to your previous question, I understand. So these 28 days you have been given on base of the partner visa application. Am I right, Ankit? Anurag is asking, can I do job ready program cash? Job ready program, the TRA has authority to request for the bank statement as well. So I would not suggest to do in cash. Just the IT return not necessarily satisfy the requirement. So I wouldn't suggest to do in cash though. Joshi Ankit is sorry, I presume basically your agent is saying April to June. I don't know what's the reason behind that though. But if you want specific answer on that one, you can send an email to me. That way I can clarify. You can call me and I'll answer your call to basically understand your exact situation, and then I can assist you on it. There is a question on Instagram. What can be the wait time or for visa to get approved in order to bring partner to Australia, and how much it can cost? I'm sorry, I did not really understand your question, but what I understand is you're asking for the charge of the partner visa application, which is $8,850, $8,850 for the department. In addition to that, you need to undergo medical examination. You need to obtain police clearance. So that will be the cost from applicant. Sponsor also needs to obtain police clearance. So that's an additional cost onto it. Police clearance is valid for 12 months. So if it's more than 12 months and the application is not finalized, you may get request to have it done again. It's same for the health examination as well. That is also valid for 12 months. So the department may request to have it done again while they are making this decision, and if it's been more than 12 months. What is the maximum that I need to stick with one employer? Job ready program allows you to change up to 5 employer. However, you must be doing with one employer at least 863 hours where you are going to perform job ready workplace assessment. All right, guys. I think that is all. I have answered the questions, whatever were available. If you are watching the video afterwards, you can send an email, or you can call us, or you can call our office, and we'll be able to assist you on all of your skill assessment query, partner visa application, or skill migration, or employer sponsor visa as well. Wish you the best, guys. Bye bye.